did not come in the list again today also. It's a new, my lord, this is a new matter. I have filed a civil appellate against the
We
single.
told you yesterday that it is something which need not be taken up immediately.
My lord, it will, the petition will become infructuous because, my lord, the notice I have challenged is not appealable and it is covered by our division bench judgment and Bombay High Court judgment. My lord, if they go with the assessment and complete the assessment order, they pass an order, it becomes appealable, then the writ becomes infructuous and not maintainable because there is an alternate forum.
So if there is an alternate, why should you invoke the writ
My
jurisdiction?
lord, because the notice was bad in law, it was out of jurisdiction. As per the
So
law,
have you responded to the notice?
yes, my lord, we had.
So if you have submitted to the jurisdiction, then how can you challenge?
My lord, in the notice, after that they have started the proceedings, my lord. There is a judgment in our principal bench of the division bench, presided by our Honorable Chief Justice, where the stay was given, so that they don't proceed with the proceedings.
Stay does not mean holding that it is without jurisdiction. The stay is an interim order.
My lord,
So therefore, if you have challenged the jurisdiction, then you should not submit to the jurisdiction. The remedy is different.
my lord,
if you-
we did not challenge in the assessment stage because we cannot challenge in the assessment stage because the notice was supposed to be issued by a different officer and it is issued by a different officer. The point of jurisdiction cannot be raised at the assessment stage.
Why? You can raise it here.
My lord, we have raised it in the read, in a
Ah.
form of read.
Please try to understand there is a particular remedy under Article 226 where you say that the authority is acting without jurisdiction.
Yes, ma'am.
What is that remedy?
My lord, the notices, the issue is with the notice.
You have filed a writ claiming a writ of certiorari.
Yes, ma'am.
That is not a writ issued in respect of a lack of jurisdiction. That is why we are asking you.
My lord, the main issue is like if they complete the proceedings, if there is no stay, they will complete the proceedings.
So therefore, we are saying if you had challenged the jurisdiction, we heard you yesterday. There is a remedy under Article 226 where the authority acts without jurisdiction. You don't submit to the jurisdiction and you seek a particular remedy which you have not sought. We are not here to advise you.
My lord, we have sought to stay over the.
But that is a certiorari. That does not mean that there is lack of jurisdiction.
My lord, I think the petition also has it of mandamus also.
Mandamus is also not a writ which is issued for
Yes, my
lack
lord.
of
And the writ
jurisdiction.
of prohibition is also.
Yes. So have you prayed a writ of
There.
prohibition?
Yes, my lord. It's-
Let us see.
my lord, point number C in the main application.
prohibition.
Yes, my lord. The writ of prohibition on the respondent authority to not act on order passed under section 148 AD or
Friday.
that it can be kept Friday.
Friday, we are saying.
My lord, leave may be granted to do it online virtually.
No. Friday we'll take it up.
My lord,
Why?
I already have a fixed 2 matters in the principal bench.
Then what can be done? Then we'll take it up on Monday. Monday. Can you just give us the order that you are relying upon?
Yes, my lord. I already have attached the order in the main petition of the Bombay High Court where the order was quashed. The
You
notice.
said that there is a order of our division
my lord,
bench.
I will-
Please don't rely on Bombay High Court. Give that order along with the slip. Monday. Monday. We'll fix it at 1 PM on Monday.
Great.
Discussion may be permitted to mention a matter, this CRM NDPS for correction.
Actually, Kotwali PS will be substituted instead of Joygaon PS.
So we are considering the case diary of which case?
Kotwali,
How do we know if you have given the wrong number?
but actually, Malad, in the order six, Kotwali PS, CD has been arrived and the your lordship was pleased to confirm the same. But in our petition, that has been wrongly mentioned as Joygaon PS. The remain portion is remain intact.
Give it for correction tomorrow.
And my lord, may I be permitted to mention one matter for inclusion in the list, my lord, interim.
This was correct.
My lord, interim bail was granted on 12/11/2024, which is expiring on 20 December.
On,
On 20 December, 20 December. My lord,
so it has not come up yet.
no, my lord, for inclusion in the list.
Yes, give it, it will come on 20th. It's lapsing on 20th. So therefore, we are saying it will come on 20th. Give. That is the one he is mentioning. What is this, sir? We asked you whether it has come. You said, no, it has come. It has been adjourned. You did not appear. You did not appear. So if it is listed, you don't appear, and then when you want, it should be listed. Very peculiar. Sir, you did not appear. The matter was taken up. If you are not, if it is not urgent for you, what can we do? If it is not urgent for you, then what can we do? And we are, now I remember, we were looking at it,
There is a mistake, my lord. I do clearly remember, my lord, that day I made a prayer for day after tomorrow. And my lord said, keep it tomorrow, my lord. That is the only,
just now you said it was not taken up.
no, my lord.
Just
I
1
have made a
minute earlier,
prayer
you
before
said
your
it was not taken up.
No, my lord, on Monday, I have made a prayer before your lordship to keep the matter day after tomorrow.
This
my
is
lord.
very unique. We don't know. The order records none appears. First you said not taken up. Now you are saying taken up. I had made a pair. There's the court granted an adjournment for not today.
Lordship,
How can it be like this?
Lordship, may I? Lordship, the CRAN one was filed, it was, the date of listing was today, 18.
The matter was taken up on 16th. There is an order passed in the case.
Lordship, that's another matter.
Let us see, just now we have been shown.
Piyush Kumar Dotto. No, we have filed one CRAN, Lordship, for extension.
It must be in that file. Huh? Oh.
That's the.
So why didn't you appear on the day when 16th it was called?
Apology, my
Apology, Lordship. What will happen if the date is
List it,
Then
then
you
we
will-
list it on 20.
20th? Grateful, Lordship.
List this on 20th.
He should have,
Apology, Lordship.
he should have kept watch with,
Lordship, he was waiting for when the CRAN will come.
he should have kept watch with, in according to the cause list.
Absolutely, you know, they follow for
I'm appealing for the petitioner lordship. I'm appealing for the petitioner lordship. This matter, the petitioner was enlarged on interim bail. As because there is a delay on the trial. And the interim bail was till 20th of December. My instruction is that since the last order, there is no progress in the trial.
Since 7th November, there has been no progress. For this, you need instruction. We can say that just like that. What progress in 1 month? What progress do you expect in 1 month? There's probably hardly been one date in between. What submission you are making that in the last?
But the order
that-
was passed for that.
What progress do you expect in 1 month? That is what we are asking you. You are saying no progress as if it is a big lapse. What will happen in 1 month? Nothing will happen.
As a whole.
How long have you been in custody?
No, I was, lordship, the petitioner was in custody for more than 300 days, 300.
Oh.
And lordship, as there was no progress in trial, he was enlarged on interim bail. Lordship.
Lordship, actually the man of Bhutan, your lordships, different state, country.
So in a matter of a year, you are entitled to bail. Let us see the law.
So that is, there is no such, but interim bail was granted as because. there
That
was-
we have seen. That does not mean it is final. So we have to consider it finally. We are asking you.
the
That
state-
Odisha judgment, even if you rely on that, we forget the name. Where even in commercial quantity on account of delay in the trial, bail may be granted. That judgment of the Supreme Court Ra-
Ravi Prakash.
versus state of Odisha. That is what we are saying, yes. So even by that parameter, you don't qualify. And what progress do you expect in a month? There will be no progress. What is to be done? Interim bail was granted. What is the quantity?
One 179 strips of spasmo of proxy-1 capsule.
179 strips of capsule.
And 96 bottle of cough syrup.
Bhutan, na, man of Bhutan.
You are having any drug license?
No,
I have taken instruction.
no, my lord, there is no drug license. If so, nothing has been instituted against them. They are carrying the medicine, but they don't have, that's why the,
Are they transporters?
no lordships.
It was being carried in which way?
Lordships, by truck, your lordships,
By truck.
Commercial.
10 wheelers, bearing the registration number BP, Bhutan
Was
number,
concealed somewhere or? it was-
consent. And they are the man of Bhutan, your lordships. Another difficulty is your lordship.
So how will you ensure your participation
Yes, your lordship, that is the only thing.
in the trial?
If there is a
Cross the
condition,
border.
if there is a condition to.
Once you
not to
cross
leave
the border, sir,
jurisdiction,
once you cross the
Not to
border,
leave the jurisdiction of the district or so, he can comply with the.
how many accused? One,
Yes, no.
Two.
both foreign nationals.
Another is absconding also. Ganesh Darji,
One is the.
Vijay Chetri.
So how he has fled away if he
So
was,
followed they took the Bhutan.
how has he fled away? He was there in the truck.
No, there is another. Subsequently.
So he has stated
yes,
about
yes,
his
yes,
involvement
yes,
also.
Yes.
May ensure your. Worship, may I propose one thing, Worship? Worship, let the interim bill be extended for a limited period. In the meantime, let the state furnish a report where is the progress of the trial. Worship. Because that direction was.
The case is of which year?
23, Lordship.
23.
May 23.
Yes, your lordship.
And you were, when were you arrested?
On the same day, same.
Is there any direction earlier to you? Certainly status of these charges?
Yes.
Lordships, the charge sheet, supplementary charge sheet has been filed. But no direction upon the state. Your lordships, they are concealed the contrabands in a cement truck, carried cement, loaded with cement.
Didn't say anything on the last day that.
Lordships, I have also stated before your lordship that they are the man of Bhutan, and even lordships.
They are submitting, but on the day he was granted interim bail, we don't find any such submission on the.
But lordships, I have already stated, and they have man of the Bhutan. I have stated your lordships.
Kindly see para 4 of the. Kindly see the paragraph 4 of the last order. Paragraph 4.
Even there is no fault on the part of the prosecution for non-progress of the trial, as because some are absconding, and the man of Bhutan, I have also stated your lordship.
Find it. Stated perhaps the order. After reflection of the previous order.
Even due to irregular, there will be closure.
Even the earlier occasion turned down, that also mentioned, but that was not mentioned, lordship.
Turned down.
Yeah, previously turned down, your lordship. Previously turned down 2 times. The first order passed by your coordinate bench, your lordships. Paragraph number 1, the petitioner
First,
renew
it was
his
not
prayer.
pressed.
Order dated 7/24.
First, it was not pressed. Thereafter, it was dismissed on me.
The FSL report has been received
Yes, your lordships.
when?
13
After or before the charge?
after charge sheet, as because the 31 dosh. Supplementary charge sheets after that.
So if it has been, without FSL report, you have submitted a charge sheet.
Yes, lordships.
Then what is the law?
So there are judgments that without FSL, the charge sheet is no charge sheet.
Saying this. Saying this.
Tomorrow, not today. Number two. Well, item two, I'm praying for next item.
Yes. Next circuit. As prayed.
Number three.
But I'm praying for next circuit.
Yes.
No.
Number four.
Before my learned friend starts, my lord, in this case already on petition number 1, that is Swadesh Shingo, he has been granted bail by the coordinate bench earlier on a occasion, my lord. The same petition in the same case. So this is absolutely the person who has sworn the affidavit, who has sworn the affidavit in the petition. He has done a perjury, my lord.
No, no, it's not like that.
Yes, on
My lord, on
oath,
the
he has
first day-
stated that this petitioners by a separate application for bail has been granted bail. And
Let me-
similar another petition pending. So, my lord, this kind of application should not be entertained, my lord.
My lord, the thing is that on the very first date, this is the third date. On the very first date, I stated that this petition was dismissed for default. In the meantime, restoration application was pending. In the meantime, that another petition, the Swadesh Shingo was heard and it was allowed bail. In the meantime, it was restored. I am not preaching on behalf of the petitioner number 1, my lord. On the last date, my lord asked for.
Because this petition has been, the affidavit has been sworn by one person who has stated that no petitions are pending. But already he has been granted bail.
No, no.
Yes.
No, no, it is in the first, that is before the granting of the bail. No, it was dismissed for
This is
default.
the earlier case.
This is the earlier case. After
So how
that,
can he say?
no,
In the earlier case, how can he say?
no,
This is the
thereafter
earlier
another
case.
subsequently another application.
So whatever has been done in that
Whatever
case.
it is, but in one of the cases.
Now that is over. This is the earlier case. If at all what you are saying is to be accepted, it may be accepted in this case, not in this case.
That's true.
Not pressed.
Not pressed on behalf of the petitioner number 1, but for petition number 2, I am ground of parity, long detention, over 3 years, 2 months. There are 23 witnesses, only
So
5.
when this was dismissed in default, another application was filed.
No, no.
Then what happened?
My lord, it has been restored.
It was dismissed for default, that's why the restored.
When was the second application filed?
After I filed the restoration application.
So at that time it was dismissed in default.
Yes. Later, the petitioner number 1 filed another petition. It was dismissed. Then
When-
after that, I filed.
Sir, we are trying to understand under what circumstance the second application was filed. Therefore, we are asking you, it was dismissed in default on which date?
5/9/2024.
And when was this filed?
This was filed much later on to 2000. It was
Before filing of restoration,
before.
filing of restoration.
Restoration I filed earlier on the last bench,
Give us date.
my lord,
One is the date of filing of this and the other is the date of filing of that.
my lord.
What are the two dates?
Yeah, that I'm telling.
Filed by different lawyers.
Yes, yes,
Different lawyer.
different lawyers.
But the person who has signed the Vakalatnama, same person, same petitioner, same accused.
No, 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 no.
And
No, Vakalatnama, that's the same person, but
when he filed the application for restoration, he has filed another Vakalatnama.
Same person.
Same person, Swadesh Singh
All
was
three wakalatnamas
filed by Swadesh Singh. So this is absolutely, my lord, if this thing,
Singh will have to be the same person.
yes.
He is swearing the affidavit.
No, he is not suing, someone is swearing on his behalf.
Filing of wakalatnama will not make him
right.
liable for this. Yes,
on the merit, my lord.
please give us these 2 dates.
Yes,
What is
2
the
days, 2
problem?
days. But just short part possible. Just short part.
You must clarify
Good.
this thing in the order.
10 minutes possible, my lord.
Not today.
Not today. Not today. Item number 5.
There's nothing about. Five. I think that same case. Is not appeared. Yesterday also is not.
Yes, Lordship, I informed the petitioner advocate, Lordship. Till now not appeared. Three times, Lordship.
You have informed him 3 times.
No, Lordship. Today I informed him.
Vikas Singh.
He has an interim bail. He is not appearing in the last 2 dates. No, not today. We don't believe in Passover stuff. We understand. We have also come from there.
I know it, my lord.
But then there is always a chance that somebody is watching from the other side. He would not know that it will be taken up immediately thereafter. So it is the best thing to do is
Procedure
keep it
acceptable,
on the
but sometimes we are
Yes.
really on legs. Yesterday happened same thing.
yes.
But so I am for the petition. The news, the only, the non-bailable section is 64(1), the rapes are the old section. The, my lord, this is a type copy of the affair, English version. Anything like to? My lord, the complainant herself said she had a love relation with the petitioner for a long days. There were intimacy. When she refused to stay with the petitioner physically assaulted him. And this is a fair conversation. Yes, for your lordship. So, my lord, here the lady, I am for 62 days in the custody, my lord. She's very candid. She said I had a love relation with the petitioner for last 3 years, some intimacy. Then, my lord, she refused to stay.
Any injury report? My lord, she was injured. There may be in the part of the fetus. Injury report.
But 62 days I'm in custody. Simple injuries.
She was assaulted, subsequently she was ravished.
That is the complaint itself says.
This is the medical report, madam.
Of the accused.
But she admitted there's coupling between the love coupling, my lord.
My lord, this is the.
Actually, that page is at in original case diary, page number 21 and 22, the medical report.
examined 2 days after the incident.
Yes.
Yes, my lord. And actually, the incident is that they both had love affairs, my lord. She was taken to a,
She has been examined after 2 days that we are trying to.
Well, 60, when he was the 62 days, I mean, custody. But she admits lab affairs. So all those, my lord,
That mean that you will.
injury, I should have supported, my lord. But he was just out of this, when she said, I had a 3 years lab affairs with him. I refused him. But your lordship can see.
Has there any
my lord, what has happened?
video been recovered?
Yes, my lord. Video and photographs are, my lord, with the accused, my lord. The videos have been sent to the, my lord, laboratory. And supplementary charge sheet. In the meantime, the victim has given the photographs. At,
But we have not uploaded
photograph-
it. I have not uploaded. There's no
photographs-
section.
Obscene photographs have been seized, my lord.
But
It
you
is
are
at
also.
the envelope, my lord. Kindly look at page number 5 of the case diary.
Those are not uploaded, but there's no section is included there.
My lord, green envelope.
You brought the report? You have brought the report? Okay, order your report. Last of the report has actually. Last of it, this court says to bring the report.
Report nahi deta.
Report nahi deta.
To represent her.
Report.
The lawyer for the DL.
You see, read down what I said. Investigation manager to come back with the report. Last order. Last order, my lord, you can see
My
the.
lord, regarding why IT Act has not been, my lord, included. My lord, actually, the IO had already given a prayer for
My lord, our earlier bench, my lord, said that to bring the report, you can see the last order, 26 November 2024.
My lord, she was pinned down and my lord, the photographs were taken, my lord. Actually, that is the case, my lord. And regarding the IT Act, my lord, the IO had, my lord, prayed before the learned court, my lord, regarding the IT Act, my lord, but the learned court said the court needs more evidentiary value for IT Act, my lord. So that is the reason why IT Act was not included.
So have you aborted it or you are pursuing it?
Regarding my lord, IT Act. My lord, IT Act, my lord, since my lord, supplementary charges is pending, my lord. So until and unless, my lord, supplementary charge sheet, my lord, I think the IT Act will be
No,
included.
no, so you are still pursuing it from that aspect.
Yes, my lord, we are pursuing, my lord.
I'm not uploaded, my lord. Don't see, I'm not uploaded. I'm threatening them. You're saying appreciate. If I uploaded, then the section can be input. You're saying appreciate. I'm not uploaded. So close.
Informant, complainant has a
I have been appointed for the legal service.
Yes, you are correct.
My lords, item number 7, I'm led by my senior who's appearing virtually.
Item number 7, my lord.
Please.
I've received the CD just now, my lord. So I require time, my lord. And this is a certified copy. Pagination is not proper. I require the original because he is a Chinese national. I require the original and the presence of the IOs.
So when do you want it?
Friday, my lord.
My lords, subject to my senior.
We'll appear on Friday. Lordship, I'm grateful. I beg to appear virtually on Friday.
The petitioner is represented through virtual mode. The learned state council submits that he requires clear and legible copy of the case diary and presence of the investigating officer to stop. He prays for an accommodation to stop list on 20.
Very deeply obliged.
Great.
Grateful.
এখন 8 হবে 8
এই নাম দিয়ে দেবো স্যার।
Item number 8, I am praying for next circuit, my lord.
Appealing on behalf of the de facto complainant, Your Lordship.
Has paid next circuit.
Next circuit. Deeply obliged.
Number 9.
Praying for next circuit.
And for the state. Yes. Has paid. Number 10. Item number 10.
I'm only praying for not today. I have received the leave in the morning.
Has paid not. Item number 11.
My lord, item 11 and 12, praying for next circuit. Item number 11 and 12.
Has paid. Has played next circuit. In both 11 and 12.
Number 13.
Lordship, I am for the petition.
The first time.
Allegation. Oh.
একটাই
Case of assault. 187.
It was taken, it was moved earlier also.
No. But I am for Dhananjay Devsharma.
There was co-accused has.
Yes. I am surrendered before the lower court on 11/11/2024. Since then, I am.
Earlier you had moved for anticipatory bail.
Yes.
No, he is in the.
I am,
custody right
I am in jail custody.
We are asking him, there is another order. He said it is co-accused. The same person's name is appearing in this case. So earlier it was for anticipatory bail. That is what we are asking you.
That should be rejected, my lord. After.
He doesn't know, he's a.
It is not known to my knowledge. After surrendered, he will.
You are Dhananjay Dev Sharma.
Dhananjay Dev.
This is your CRMA 92. A means anticipatory.
Yes.
I mean, that.
From 11/11/2024. Charge sheet had been submitted.
Not the assailant.
Not the principal assailant.
Any past incident.
There is no reflection in the case diary.
Learned state counsel. There is an allegation that the complainant has sustained a deep cut injury on his neck as a result of the assault perpetrated by accused person stroke S. Submitted by the counsel for the commissioner that from the statement of the victim recorded under section 161 CRP, it is obvious that there is no overt allegation against the petitioner, as the assault is alleged against the other co-accused persons.
Number 14.
Lordship, I'm paying for next Sunday.
Yes.
14, I am appealing for this state.
Not today, Lordship. I'm paying for not today.
Why all these matters are repeatedly being adjourned?
Yesterday taken up the matter and they said that they will come with the certified copy as because charge sheet has been filed 2014 in place of 2019. Your Lordships hold the matter at length, your Lordships. And now they are taking avoiding policy, your Lordship.
Let it go in the next circuit. A spread list in the next circuit.
No, 20, I am for the state, your Lordship.
It's the fourth application.
Fourth application.
Well,
How long have you been in jail?
no, it's an act.
Anticipatory, fourth.
Well, it's firstly, it was dismissed for default. Subsequently, it was heard on merits and it was rejected. All the order sheets are annexed with your Lordships.
Starting from page number 11. Merely on mercy application. Who accused my brother? He has been granted bail by the learned court below. Charge sheet has been submitted. And in the charge sheet, there is no prayer for filing of a supplementary charge sheet after my arrest. And my lord kindly considers one thing. The prosecution did not take any steps to arrest me, although I was there in the locality.
Lordships, I will invite your lordships, 164 statement and the.
No, we don't want to. Why should we? The court has already recorded everything.
Well,
Why are you repeatedly filing?
that explanation is not there even.
Then he should suffer some consequences for this, whoever is followed.
And it's the reason why I started, it's a mercy application. Your lordship
Yes,
kindly considers.
the court has considered 164 statement, injury report, extent of complicity.
But it's,
After that, he filed, he has not pressed, and now he's filing again.
my lords, the court has considered prior to filing of the charge sheet. Subsequently, when the charge sheet.
And on 11/9/24,
My
No,
lords,
charge sheet
charge
has
sheet
been
has
filed
been filed on
on
30th of April 2020.
24.
And
so
I.
therefore, we are saying on 11/9/94, he has withdrawn it. After charge sheet also.
Now, after charge sheet, it was dismissed for, it was non-prosecution.
So therefore, it was submitted by you that you don't want to proceed with it.
My
So you are burdening the court with unwanted litigation and application for no purpose.
Lordship may kindly be disposed of. I know. the meaning. I will go for it, then I can before your lordship. I know the meaning of the dispose means reject the bail applications and dispose.
This is a very unfortunate circumstance, as will be apparent from the sequence of events emerging from the bail application itself. So, the first application of the petitioner filed for anticipatory bail, CRM within bracket capital A568 of 23, was dismissed in default on 7/8/23. Stop. No restoration was filed. To stop. A fresh application for anticipatory bail was filed. CRM within bracket capital A740 of 2023. To stop. This court, considering the material in the case diary, including the statement of the injured recorded under 164, injury report, and the extent of complicity in the alleged offense, has rejected the prayer for anticipatory bail since the investigation was still continuing. Stop. After completion of investigation and submission of charge sheet, on what is the date of submission of charge sheet?
Charge sheet, lordship.
3/4/2024.
3/4/2024. 30/4/2024. A third anticipatory bail application was filed bearing CRM within capital A 598 of 2024, wherein upon instructions of the petitioner not to proceed
Item number 21.
Arm for the state, your lordship.
Lorships, I'm praying for next circuit.
Yes, as per.
Number 22.
You are for?
What do you come? What do you come question there?
Where is the FIR?
Well, this is the clear copy. Still
Page number 8. Fair, page number 8.
What do I think number? Item number? Number 22. 22. 22. Petitioner. Horikanto Singh. Horikanto Singh. FIR has been lost on?
FAR lost on 19/10, 2024, 19 October 2024.
This one is the 19/10/24. So this one is 22.
First FAR which was sealed envelope.
PS case number 62 of 17. PS case number.
She has lost another case earlier
Not
also.
earlier, another case, this was acquitted by the court, and thereafter it present complaint.
Same allegation.
Not same, near about same,
No, but you have annexed the earlier FIR.
yes, ma'am.
You have not annexed the present FIR.
I present the affair in sealed envelope.
Oh, indeed, that is in the envelope.
In the sealed envelope. Present envelope is the sealed envelope, first affair, the second affair, and the judgment.
So this is the FIR.
Yes, ma'am, this is the affair. This is present affair. But the earlier affair and the judgment.
Yes. What was the earlier, that was, in that allegation was also against you. What was the allegation there? In 2017 also. For few days.
There was from that house, he was taken to another house. And from that house, she fled away to her husband. But there's a delay and another thing is that there's a estimated relationship. Estimated relationship and she stayed to the person there. There's the earlier case and case. All these things are husband.
We are asking you what was the allegation in the earlier, can you? In the similar way, I need to understand, therefore I am.
She stayed together for 26.
No, she did not. She says for few days. Few days does not mean a month. It may have been 4, 5, 6 days or 7 days, whatever. In her statement, what has she said?
Yes, sir. This is it. What's it?
After acquittal, after 2 days of acquittal, this case was.
So from 15/10/2024 she retired. Yeah, this is 19/10/2000. From 15/10/2024 yeah. Medical report.
Medical is in an envelope. 29.
Are there any one?
Lordship, on behalf of the factor company, Lordship, putting the lady in the fear of death, abduction was committed, Lordship. Again, putting her in death fear, numerous times rape was committed, Lordship. Then again, she was also tortured brutally, thus 307 was given. Now, in order to get rid of the evil situation, she somehow flew from that custody and came at her husband's house, Lordship. And then previously there was an enmity between the accused and the de facto.
What is the date on which you were examined medically?
Medical examination.
19th.
Lordship, it's in the
19th October.
Next.
Both normal or no, no. 16, 17, 19.
For the petitioner and the learned state counsel, the de facto complainant is also represented. On what is the date on which she has alleged that she was 22nd September 24. It is alleged that the de facto complainant was forced to go along with the present petitioner, where she has been confined for few days, subjected to repeated rape and assault. Stop. It is alleged that sometime later she has managed to flee away and lost the present case against the petitioner. Learned counsel for the petitioner submits
Yes,
Number 24.
My lord, there is a, my lord, allegation of, my lord, abduction and kidnapping by the petitioner number 1. My lord, the petitioner number 1, my lord, aged about, my lord, 20 years. The victim girl aged about 13 years. They are the, my lord, inhabitants of the same locality. My lord, all the family members of the, my lord, the boy has been, my lord, entangled. The entire family members, father, mother, and my lord, the victim girl has already been recovered. She is, my lord, now safely with her parents.
She is recovered. Her statement has been recorded.
164 is there and medical denied. From the previous page also, my lord, 2 lines in the previous page. No, from on the 164.
The petitioners are
Others, my lord, the petitioner, my lord, first lodge an FIR, page 12, my lord, kindly have a look.
Petitioner's complaint is prior,
Prior to, my lord, this instant complaint against which
both are alleging assault against each other.
assault and, my lord, rivalry. With regard to, my lord, a land dispute, my lord, partition of land.
Have you sustained any injury in the earlier complaint?
My lord, I have sustained an injury, but my lord, I have not annexed any. report.
Has he annexed any injury?
My lord, that may be in, my lord, the his diary. ma'am. So in retaliation, the second,
You mean prior means on the same day,
on the same day,
earlier case number?
on the same day, earlier case number was mine.
In respect of same incident.
With respect to the same occurrence.
Lordship, out of the same allegation, my lord, same incident.
Can you read this? Can you read the description of injury?
One trauma, body trauma,
Can you read it? We are unable to read.
Initially it was.
Yes.
Thereafter, good years.
beaten by lucky sticks. Trauma, stitch index finger of right hand.
Stitch
Pain and
only.
swelling. Pain and swelling, index upper finger, grievous.
Have you sustained any injury?
No, my lord, I have not annexed, but so far I have been instructed. There was a confrontation between the, my lord, the brothers.
What is the
their fa-
FIR? What does the FIR say? Have you annexed the FIR?
12, my lord, page 12. This is my FIR, my lord.
No, where is the FIR against you?
Acha, my lord, that is page, my lord, 11, written in Bengali, my lord.
Obviously. Any suit is also pending.
No, my lord, no. But it has been stated that a land has already been, my lord, gifted out.
Statement.
The informant in the present case.
But no murder weapon has been used, only lathi, some,
No, we are just trying to ascertain what is the bone of contention.
my lord. The genesis of the entire incident is, my lord, for taking possession of certain plot of land. That has been, my lord, categorically
They are
stated in the
residing- they are
FIR.
residing in the same plot.
Lordship, with regard to taking possession of a certain plot of land, the, my lord, the
Certain
dispute
portion-
cropped up.
Certain portion in between the two brothers.
Yes, lordship, yes. That is the, my lord, the genesis of the entire incident.
They are own brothers, full brothers.
Full brothers, my lord.
The petitioner is the accused.
Twenty-six, I'm going for next circuit.
Has paid next circuit.
Number 27.
27 and 20 not to the ballot. Not to the ballot.
Number 30.
Printer no.
Yes, not today.
31.
For the petition. Not to the. This is an application for anticipatory bail. I am the Indian citizen. And one Bangladeshi national was arrested and he revealed my name. This is the whole about the allegation.
In manufacturing documents,
No, my lord,
then
that I gave allegation of harboring. That I gave them shelter. Charge sheet has been filed and the Bangladeshi national is in custody. My lord, so far my knowledge goes, there is no prima facie materials to show that I was involved in the connection with this case and I am not history sitter, my lord. They came with India with an intention of stealing cow. I was not at the SPO. my lord.
in the FIR you have not been named.
Yes. Number 9. That is from the mouth of the other accused party. I named in it.
There is no allegation of harboring. There is no allegation of harboring. You are alleged to be an associate, not harboring. Harboring is a different thing.
I have said that I am an Indian citizen.
Yes.
According to the evidence. But not in age, not a language.
Yes, take down. This is anticipatory. No antecedents.
Good.
4 to 5 cattle smugglers were moving along the Indian border. When the officers rushed to apprehend them, all but one has fled away. The individual who was
My lord, admittedly, my lord, 49 bottles of my lord contraband drug has been, my lord, seized from one Shamrat Acharji. He was caught red-handed. From his possession, my lord, the entire contraband article has been, my lord, seized. He was placed under arrest. My lord, during the police custody, this petitioner's name has been, my lord, revealed.
What has he said about you?
My lord, my lord, nothing, my lord. No, not a single drop of, my lord, contraband article has been seized from my
What has
possession.
he said about you?
My lord, that, my lord, he purchased, my lord, the contraband article
From you?
from me, and my lord, he is going to deliver it to somewhere else. That is, my lord, has been, the police extracted the confessional statement during custody. And that is, my lord, the origin of my involvement in this case.
Yes, any,
The statement is here, my good statement. Acquaintance,
acquaintance.
used to do business together, but nobody going from.
Purchasing the present seized item.
And another person's name was also, my lord, revealed.
Few of them used to do it. Show the Parma.
Specifically does not be stated, but he's about some business terms.
Yes. Our land council for the petitioner and the land state council. There is recovery of 49 bottles of cough syrup having codeine phosphate from a person to stop. The accused from whom the recovery has been made has stated about being on business terms with two other persons, including the petitioner. So it is submitted by the learned counsel for the petitioner that even if the statement of the accused from whom the recovery has been made is taken at its face value, the same does not connect the petitioner to the present recovery, as it merely indicates an acquaintance. Full stop. Learned State Council submits that the petitioner's name has been stated by the accused from whom contraband has been recovered. Considering the rival submissions, the nature of statement which we have seen from the case diary, the fact that the petitioner has no prior antecedent, and also the fact that there is no recovery of any contraband substance from the petitioner.
My lord, I am on behalf of the petitioner, my lord. Lord, to what my instruction goes, my lord, the petitioner number 1 was served with a notice under section 35(3), and the petitioner number 2 was served with a notice under section 35(3), one on the 12th of December, one on the 15th of December, my lord. That is the instruction that I have received, my lord. And my lord, they are to they've been asked to appear tomorrow at 10 o'clock, my lord. Kindly have a plenary reading over the FIR, my lord. My lord, my lord, kindly, my lord, kindly.
Where is
My lord,
the apprehension of arrest?
my lord, I am telling you, my lord. My lord, my lord, I shall satisfy the malafide by the complainant, my lord. This complainant, my
We
lord.
are not considering the malafide. We are only considering whether you have an apprehension of arrest
My
or
lord,
not. We are not concerned with malafide and bona fide of the complainant. Whether you
My
have
lord.
an apprehension of arrest
Yes,
or not.
my lord, I
How
have an
can you say
apprehension
you
of-
have an apprehension of arrest?
My
when
lord,
a
I was
notice has been
detained,
issued?
I was detained for 8 hours just to serve this notice, my lord, on the 12th.
We are asking you, where is the apprehension of arrest?
My lord, let there be an interim protection, my lord.
What interim protection? You go and comply. You go and comply with this. Why interim protection?
Lord, kindly
Then
let-
everyone who is issued a notice should go with a order from the court that there is an interim protection. Then what is the statutory provision for?
My
Just
lord,
because you have filed, therefore some order must be passed.
My lord, kindly goes through page 4.
We are not required. We are just to see the notice, nothing else. We have no concern with the allegation. Because we are only to see whether there is an apprehension which requires considering of the prayer. There is no apprehension. You have been asked to attend the questioning only. That is all. Nothing. Go and comply. The
My lord, I shall comply, my lord. That may be noted down, my lord.
the petitioner's counsel submits that a notice has been issued under section 35. No. This in BNS it is 35. 35 of the BNS. Yes. What is 326? What is 326? What is it?
118.
Grievous.
3 injury reports are there, Lordship. Out of 4 injury reports, 3 injury reports are simple in nature, and 4th could not be determined because referred to higher center for ophthalmologist checkup.
Eye.
Redness in eye, redness in eye only. Another three injuries are simple.
What has happened? Scuffle between the neighbors, their neighbors. The petitioner is accused of assault upon the informant. It is submitted by the learned
Yes.
35.
Complainant and petitioner, they have having a last relationship, and thereafter, allegation that the petitioner is appropriate some money of the complainant. So totally for the last relationship, to when the petitioner denied to marry, or
She is the major.
Lord, medical report, page 13.
Amount that is took money from the bank or the complainant.
Bank.
That is.
Took money from the bank.
Of the complainant.
allegation that is not deposit the money in the bank.
Complainant has alleged that that the petitioner, she
Number 36, after the petition. Though the case was related to section 103, that is section 4. If your lordship consists, page number 10 to 12 of my application, that the judgment of the observation for the honorable court has been, but the person standing on the similar footing got the privilege of PRS. Actual fact is that at the rooftop, all the persons are playing cards. In the meantime, from the downwards, a noise come, police. They have said that the police will going to raid them, they jumped. Accidentally, this victim succumbed to his injury.
You were also playing cards.
Lordship, all. 164 says this.
So he has
164 says this.
he has lost his life.
Lordship, that person died. All of them jumped, but that person fell upon the wall.
All of
and
them
died.
So did you sustain any injuries also?
No. Except that person, nobody sustained any injury.
Because two of them, they came down through catching the rainwater pipe, and two jumped. One died, one injured. He was also enlarged on bail. So here is the 164 statement. And this is the eyewitnesses.
So whose statement is it?
Eyewitness, the neighbors, who after hearing went there and they state logic analysis, page 45 to 49 and 60, 62. The person who rescued them took to hospital.
There are two orders, my lord. The person standing on a similar footing got the privilege of
That Shibu earlier granted bail, he sustained also injury. And this petition.
And Bhaskar?
No, Bhaskar did not sustain injury because he came through.
So he is similarly
similarly
situated.
It was a single-story building, but that the person who died, he fell upon the wall, Lordship. So what happened?
He fell on the boundary wall.
Final got cracked and died. 162 statement.
Land Council for the petitioner and the Land Council for the state. As prayed, next circuit. As prayed Monday. Jumping from the roof.
Same incident.
Same order as 36.
Same incident.
Same PS case. Next circuit as prayed.
My lord, I am appearing on VC. My lord, this is I'm appearing on behalf of the petitioner, who is the named accused number 1, who has been convicted under section 392, read with section 397 and 326 of the IPC and section 25 and 27 of the Arms Act. He has been, however, acquitted of there were other charges on 307 and 120B, for which he has been acquitted. Now, my lord, my case is very in simpliciter. The maximum the punishment that has been prescribed for him is to sentence has been to suffer simple imprisonment for a period of 10 years, and he has already been in custody for over 7 years. As on date, he has been in custody for 7 years, 3 months, and 10 days. My lord, since his arrest on 8/9/2017. My lords will appreciate that the Honorable Supreme Court has, in Saudan Singh, has laid down very categorically that for offences which are punishable with sentences which are not life sentences for life imprisonments, if the convict has already spent more than 50% of his sentence in custody, then normally bail should be granted under section 389. And this has been further reiterated, my lord, earlier this year in Atul Singh versus State of MP. If your lordships so desire, I may provide the citations of these 2 judgments which I'm relying upon. My
Yes,
learned junior colleague.
Give it.
I don't have the judgment.
My lord, Saudan Singh versus State of UP is 2021 SCC online. SC 3259. Para 7 is the relevant paragraph, my
Yes.
lords.
Where is it? Give us.
My lords, I don't have a.
Your junior does not have the
My
judgment.
my lord, I apologize for this. My lord, may I just give may I just quote the paragraph, place the paragraph, the relevant paragraph before for your lordship's
We have had
consideration.
the opportunity of seeing Saudan Singh earlier. Which is the judgment? Atul Singh judgment?
Atul Singh is Atul versus State of MP. This is 2024, 3 SCC 663.
Which paragraph?
2024.
In Atul Singh, my lords, the relevant paragraphs are 2, 4, and 5.
6.
So you are one of the persons who entered into the shop, but only one has fired upon the guard. So who has fired upon the guard?
My lords, it has been alleged that I have fired upon the guards, but my lord, I stand a good chance to prove my innocence in appeal.
We are not
Because my
asking
lord,
you to make submission.
recovery.
We are trying to ascertain the allegation. There is an allegation of firing against you.
Yes, my lord. My lord, the allegation, my lord, if I may place this, the allegation is that there are difficulties in ascertaining my identity because according to the onlookers, we were wearing helmets, and it is the case of the prosecution that the person wearing helmet was firing upon the guards. There is a major question, a contradiction in terms of the my lord, for the
How many total number of persons? How many total
3.
number of 3?
3.
And firing is alleged against 1.
Yes, my lord.
Firing is alleged against 1 out of 3.
My lord, allow me a moment to place this before your lordship.
There are 3 persons.
There are 3 persons.
307 acquitted there.
No. We are trying to ascertain what is the allegation. You all are making submissions. We want to know what is the allegation. 3 persons entered the shop with the motive to commit loot.
Yes.
Out of these 3, 1 fired, or there was a 4th person?
My lord, there is a.
Out
My
of
lord,
these
if I.
3, 1.
My lord, the prosecution case in brief is that one of the accused persons, the identities were not ascertained at the
1 out of
place
3
of.
or 1 in addition to 3? How many times do
One
we have
out of
to?
three, one out of three, my
Give
lord.
us
one
a
out of
clear
three.
answer first, then we'll proceed.
It says one out
Yes.
of the three accused persons started to
Alright, so
fire
now
at the
you are
security
saying-
guards. One out of three, my lord.
The, yes, all right, heard counsel for the. There is a CRAN filed for bail.
Yes, yes, my lord.
Yes.
Heard the learned counsel for the applicant as well as the learned state counsel petitioner is stated to be one amongst the three persons is convicted of the allegation, the substance of which is that three persons entered into a jewelry shop with the
A jewelry shop.
motive of committing loot. To stop, one out of these three persons has fired upon the guard. To stop, the learned counsel for the applicant submits that insofar as the identification of the person who fired upon the guard, evidence is not, there is insufficient evidence, as it is obvious from the prosecution case that the person who was firing upon the guard had concealed his identity by wearing a helmet. So the evidence, the trial court judgment is criticized in many ways. Stop, the learned state counsel submits that upon consideration of the entire material, the conviction has been recorded based on evidence appearing in the course of trial. Petitioner is one of the three persons who entered the shop. Considering the rival submissions, one more submission. The learned counsel for the petitioner refers to two decisions of the apex court, one in the case of Saudan Singh and other in the case of Atul Singh, 2024, 3 SCC page. 24 page.
This is MP Atul versus State of MP 2024 3 SCC 663.
663 to submit that the petitioner has already remained in jail for 7 years, 3 months out of the 10 years punishment awarded by the trial court. So, considering the rival submissions, decision stroke S of the apex court and the period of the period spent by the applicant in jail, viewed keeping in background the fact that final hearing of the case is unlikely in the near future, we are inclined to allow the prayer for bail.
Grateful, my lord.
Grateful.
Grateful, my lord.
Lordship service may be kept on it.
Affidavit.
Affidavit.
Affidavit of service and the
নাম ওখানে আছে। I'm grateful.
Additional district and second court. Now 44.
Lordship praying for next circuit.
Yes, that's good.
I'm for the state, your lordships. Here a petition I have been directed to. I'm for the petition. Lotships are combined. And opportunity for filing evidently in opposite direction.
Time granted earlier for filing affidavit in opposition is extended by 1 week. By 1 week from date.
As per direction, I have copied and indicate the place and talk with the neighbors. And they have stated that yes, that person had been to the place.
Let him file, then we consider. List in the next slide. Next.
Grateful, Lord.
Now 46.
Well, 46, my lord, I have, my lord, affidavit service in respect of the accused of been not completed, my lord. Next circuit, my lord. I am for accused. Cancellation, my lord, defect of file.
Now 47.
Well, 47, well, I am for the petition. Well, this is an application for relaxation, my lord.
Relaxation.
Of condition for the direction to attending the before the investigating officer, my lord. But now charge sheet submitted, my lord.
No charge sheet submitted, we are asking. You need a clarification.
Well, otherwise I will be.
Just read the order, sir. That's why I was discussing with you. But shall meet the investigating officer once a week till such investigation is complete. If you tell exercise. Petitioner, application has been filed and a submission is made that the condition requiring the petitioner to meet the investigating officer be relaxed since investigation is complete
Lordship, for item number 48, I appear on behalf of the petitioner. Lordship, it's a relaxation modification application that I've filed. Lordship, on 26th of November in the last month, these two petitioners were granted bail. One of them were released because he could furnish the said bail bond, but the other petitioner, he could not be released because he is going through such onerous conditions that he cannot produce the said bail bond of 25,000. So Lordship, my prayer is only that if that could be reduced to rupees 1,000.
1,000.
Yes, your Lordship, he was a mere khalasi in this, he's unable to furnish any money at all. Still in custody since 3 years, 9 months.
3 years, 9 months. Commercial quantity.
Lordship,
Yes, commercial quantity, obviously.
yes, your Lordship, commercial quantity.
Due to delay in trial,
The
due to
bail was
delay in trial,
granted.
the bail was granted. My objection may kindly be noted.
Serious or just
Objection, objection.
Yes, the present application seek these matters where modification is filed, even though order is passed by another bench, here it is being done.
Yes, my lord. Modification and minor corrections, your lordship return the jurisdiction. But if your lordship have to go into the merit of the order to pass any modification order or anything, that Has to be referred back to the honorable judge who passed it. Like Lordship, what we get corrected is Mr. Singhania's name as came Ajay Singhania, he was written as Ajay Sinha. That can be corrected. But if it touches the merit of the order, the honorable judges generally refuse.
Yes, what is the present matter?
My lord, it is an appeal against the order passed by the honorable single judge, whereby the honorable judge was pleased enough to uphold the dismissal order of the appellant. It was a disciplinary, judicial review against a disciplinary person.
Oh, that's paramilitary force.
SSB.
SSB. He was arguing day before yesterday. You were not here. He has argued quite at length. I saw him in the first half.
My lord, one thing that your lordship knows very well, I did not carry the course to the Newcastle, that judicial review will be invoked only if the punishment awarded to the delinquent is shocking to the conscience of the court.
No, if there is a procedural violation, the
Lordship,
rules are procedure are not.
We'll come to that later on.
Then
What
it
happened
can
here
be
was
pursued.
a SSB sentry guard.
An
while on-
appeal regarding the decision-making process and not the decision itself.
Right, sir.
That is the
So, my lord,
judicial
in
review.
this case, what happened, he was given a sentry duty. He was guarding the sentry post.
We have seen that he has pushed a cartridge in the live chamber of the
That is why
rifle.
first he was given a 40-day imprisonment, which was
So
cancelled.
that is what he was saying. Once he has been awarded a punishment, who is the competent authority to take such a decision and within how much time?
Lordship, when the punishment was annulled by whatever officer, he never came up and said that you cannot annul my punishment. You are not the competent officer. And when the same officer in the same order said proceed accordingly, then
But
he
it's
did
a
not tell.
composite order. It's not, there's not two orders.
No, there's only one order.
So therefore, how can you say that he did not challenge both these?
No, my lord,
aspects?
that order was never challenged of 14 to 20.
So that's why we are asking you, there are two orders.
After that,
One is annulment and then
subsequently he was removed from service.
So why should he challenge an annulment, an order
Because,
which is to his
Lordship,
benefit? Why should he challenge?
I'm coming to them, my lord. That 14 to order gave the birth to the second proceeding.
No, so 14 to order, does it say that further proceedings are
Yes,
required?
it is very clear that the DIG was displeased with the proceeding. The punishment given to the petitioner was not commensurate with the offense committed by him. This sort of lenient attitude not to be shown.
Still, even
No,
if
my lord,
he
if
has,
your lordship wants to,
even if he has not challenged, then by consent can a jurisdiction be vested in an authority which otherwise the statute does
No,
not
my lord,
confer on him?
that authority had the power to annul.
So therefore, that's what we have to see.
That authority had the power to annul. But my submission before my lords is this: when the same order said, my
Where
lord,
is he? He was
my lord,
here
once if
just.
your lordship wants to come back after lunch, let it.
Yes, it is already time. In fact, can you send word to him? He was here a while ago.
I will try to locate
We have just seen him.
I will try to
maybe
locate
1 hour back.
I had seen him in the morning also.
Continue.
Come back and
You located him. Ah. None appears. Next circuit. Yes, you give your appearance. None appears on behalf of the petitioner. Mr. So-and-so is appearing on behalf of the respondents. List in the next circuit. Call the list.
Item number 50, 51, 52.
Lordship, item number 52, I'm praying for not today, Lordship.
Yes.
Wait for Lordship.
53, 4, 55.
Praying for next circuit.
Next circuit as prayed.
56, 57, 58.
Lordship, praying for next circuit, 58. 58.
Next circuit as prayed.
9, 60, 51.
61, I'm praying for not today, Lordship.
62, 50, 54,
64, next circuit. 65.
As prayed next circuit.
65, 66.
Lordship, item number 65, I'm praying for next circuit, Lordship.
As prayed, give your appearance.
65.
6, 7, 58.
Lordship, item number 68, not today, Lordship.
8,
Not today.
59, 70,
My
71.
Lord, 71, praying for next circuit, my Lord.
As prayed next circuit. 71.
72, 73, 74,
As prayed.
75, 76, 77, 78, 79, 80,
As prayed. 80.
81, 82, 83. Next circuit, 83. 84,
My Lord, next circuit, my Lord.
84.
Yeah.
85, 86, 87, 88, 88.
88, your Lordship, there was a direction to file affidavit by the rest.
You want to appear?
So we are the appellant.
Therefore, we are asking you, you want to make your submission?
But only that there was a direction upon the respondent to file a affidavit.
Either it is taken up or it is not taken up tomorrow, not today.
But then my lord,
Monday, your Lordship.
As prayed by learned counsel for the appellant, list on Monday.
Monday, your Lordship.
85.
88, appellant. 89.
88, 85.
You have to respond.
Not today.
Did I not? 90, 91, 92, 93, 94, 95.
95, your Lordship, can you fix on Monday, your Lordship. This week to kalke hobe, kalke advert.
As prayed next circuit,
Friday we are not available.
all the next case.
Our personal difference.
96, 97, 98, 99.
98, Miller, 98, 98, Miller. 98, Miller can keep it before the next circuit, Miller.
All right, as prayed.
98.
99,
Obliged.
101, 102, 103, 104, 105, 106, 7, 108, 109, 110, 111, 12, 13, 14, 15, 16, 17, 18, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128,
Monday.
129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 41, 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 151, 152, 153, 154, 155, 156.
I don't know, 73, 75 and 70. Only please take next circular. I'm for the appellant now. 73, 75, 76.
You are appellant in all these matters. Give your appearance
73, 75, 70.
as prayed next circuit.
73, 75, 76. Each.
দাদা 98 কিন্তু আদারটাই টাইম নিল ওরা রেসপন্ডেন্ট
না, আমার টাইম না।
98
না।
তোর না অ্যাপিলেন্ট আমি তো টাইম নিই নাই
হ্যাঁ।
98 এ
হ্যাঁ, for the response.
একটাই আছে।
না 98 এ কিন্তু আমি অ্যাপিলেন্টস এর টাইমটা নেই কিন্তু 98 এ কে অ্যাপিয়ার করেছে অনলাইনে হ্যাঁ 98 এ 98 এ
95 এর response।
হ্যাঁ আমি অ্যাপিলেন্ট ওটাতে এই যে 88 89 95 কি বলে দাদা 98 এর নাম্বারটা বলুন তো নামটা আমি অ্যাপিলেন্ট 98 এ আমি অ্যাপিলেন্ট কলকাতায় যে অ্যাপিল করছে সে রেসপন্ডেন্ট তো হ্যাঁ আমাদের টাইম না রেসপন্ডেন্ট হ্যাঁ রামমারো আর আমি হ্যাঁ রামমারোর নামটা তাহলে বলেন তো ওখান থেকে আরেকজনের নাম দিয়ে দিই চিঙ্কি আর আমার দিয়েছি চিঙ্কি ওটা চিঙ্কি আর রামমারো শুধু রামমারো এক সেকেন্ড দাদা রামমারো দাদা এই যে চারটা স্লিপ 98